Just to reiterate what you said earlier, children get removed from poverty.
Yes, they do.
Are there any other things that they really... Do you find that there's some type of profiling that takes place by chance?
Yes, there certainly are. There are some things that there's going to be some market changes, I believe. One of them is mental health or disabilities, or mental disabilities.
Mhm.
And that can be anything from cognitive, what we used to call retardation, or mental cognitive disabilities, as well as it can be issues with bipolar or some delusional disorder or something where somebody's just not functional. Now, under Tennessee law, and I believe under most states right now, that mental incompetence is a ground for termination of parental rights without any showing of harm to a child. So you don't have to show willfulness. You can just show that they're mentally incompetent to care for their child, and you can terminate.
And how do they prove this, or they just...
Well, yeah, sure, they prove it. I mean,
the assertion is the proof, right?
Just like they prove anything.
Yeah, I know.
But
okay.
if they find the person is mentally incompetent, they can expand that. What if they can't drive? Are they mentally incompetent to parent because they can't take their kid to the doctor?
There you go.
They might not be able to get to the grocery store when they need food, right? So this is a big issue, and I am really being a real fighter on this, and I think I'm making some headway on it. I have a case, and knock on wood, it's going to come out any day, and maybe before you get this video up, but I have a case pending before the Sixth Circuit Court on Americans with disability rights and parents' rights, because in 2015, there was a mother up in Massachusetts named, her faux name is Sarah Gordon. It's called the Sarah Gordon case. That's not her real name. But she had some mental disability. She had a small child. She truly would forget to feed it or forget to take care of it, and they took it away from her. And her mother, so the maternal grandmother, stepped in and said, I will take my daughter into my house. I will take her baby. I will help her parent. And the CPS said, no, can't do that. We're going to adopt the baby out. And so somebody was able to get the Department of Justice to come in and do a full investigation, and they said that that was a violation of the Americans with Disabilities Act, the first time we ever had a case on that.
Wow.
And
Good.
so at that year, I had a case here in Tennessee where I brought that case up and I put it before the courts, and of course our state courts were like, no, it doesn't apply, there is no accommodation, you didn't ask for accommodations, you didn't do this, so I took it to federal court. So federal court in Tennessee dismissed it, saying that he had not requested accommodations. So I took it to the Sixth Circuit, which is where it's pending now. And we had no good law on, there's under ADA, there's Title I, Title II, and Title III. Title III is employment disability, so we don't, Title II is the agency disability. So we didn't really have any good law under Title II, but I was able to pull all the Title III cases, because if you actually read the language of the federal law, it really reads the same as far as what the requirements are. And so I pulled all of the Title III cases, which are some really great law, and basically the law says that if the agency's on notice that there's a disability, it is their obligation to then sit down.
This is beautiful.
Sit down and engage in an interactive process with the person to find out how their disability will affect their ability to meet the requirements or to not parent their child. And a reasonable accommodation.
That's beautiful.
Yeah.
I love it.
And a reasonable accommodation is having a family member assist you in parenting.
Yes.
And that's what we had requested for this young man in Tennessee. So that's we have oral argument hopefully, and it's I don't know what's going to happen. The state of Tennessee is kicking and screaming about it because it's money damages, and there's no immunity. There's no 11th Amendment immunity for the state under ADA if it's a constitutional issue, and parenting is a constitutional issue. So we're going for a good opinion, number one, and we're going for money damages. So this is huge for parents. And I finally, and when I started working on that case,
Yes.
I pulled up the ADA policy for the Tennessee Department of Children's Services, and the only ADA policy they had was for employees. So if you were an employee with a disability, they had an ADA policy. They had no ADA policy for parents.
So sad. I feel so sorry for them right
I
now.
know, I know. And so they have now changed it. They finally in 2016 or 17 went in and changed their ADA policy. And in the cases that I've had, I've got a case now with a disability, and they have been over backwards. They had like a whole meeting on what is your disability, what do we need to do to accommodate you, and I'm like, and I want it documented, I want it in the records. So that's a huge step for parents and family.
Yes, I'm glad you're fixing it now, but we still have this other case over here that we're still going to take you to the cleaners on, right?
Yeah.
Yeah.
Yeah. Yeah. And I'll tell you, since we're talking about that, I want to talk about another case that just came out.
Okay.
It's not my case.
Okay.
But so I'm in Sixth Circuit, and this case may not be, so that's Tennessee, Kentucky, Ohio, and Michigan is the Sixth Circuit. And this case is in Kentucky, but it's over by Cincinnati. It's in Covington, Kentucky. But roughly it's a case where a mom had a baby, her and her husband had other children, and they got married, had a baby. She had her baby. She had a drug test after her delivery that had some questionable results, right? And so they put her under this big scrutiny, put her under a safety plan, all this stuff with her baby, have them invade their life, go to school, interview their kids, pull their kids out in secret. And she told them, she's like, I had a poppy seed bagel. You need to know that because that'll give you an inconclusive result for opioids. And then there was something else. And they got their kids back. Well, they sued in federal court, and the district court judge, they tried to get dismissal. The state tried to get dismissal, and it was denied. And it's a great opinion, and I think it's called Shulkers, SCHULKERS, but it's a SCHULKERS. And the district court ruled that it was a constitutional violation to go to school and take those children out of school and interview them, which is huge.
That's another beautiful. I love it already. So. And
he also ruled that interfering with their life on their newborn was unconstitutional. And I'm kind of proud because one of the cases that they quote in there was one of my cases back, the Andrews v. Hickman County case, which I got out there and I didn't hardly know what I was doing back then, back in like 2008. But there was a Fourth Amendment violation with social workers, and I just took it up there and took it to Sixth Circuit, and I got, we ended up not getting a great result, but we got a really good case opinion that the Fourth Amendment applies to social workers. So that's just come out. That's a great case for families. There's some stuff that's slowly starting to happen.
Do social workers have the right to lie?
No, they don't. But
I thought it was a constitutional right that we have a right to lie, to try to entrap a prayer and to say something that. Let me share with you kind of where that is in the courts. A lot of people are familiar with the Hardwick case out of the Ninth Circuit. That came out in January 2017. Right.
And if you watch that opinion, that argument, it's a great opinion because basically they say there that the state attorneys are ridiculous because they're like, well, we didn't know it was a violation.
Seriously?
Yeah, and the judges are like, are you saying that your people are employed by you do not know that perjury is a violation? Now, they found
it's not perjury if we do it.
Yeah, exactly. Well, we're just mistaken. But they found that, so qualified immunity, it has to be a clearly established constitutional violation when it occurred. Okay, so that came out in 2017.
Okay.
They were not granted immunity back from when that happened. So it happened in like 2000, that was a 2017 opinion, and it takes like 3 or 4 years to get to court.
Right.
So that was like in 2013 or so, 14, right? I just have a case I'm taking in the Sixth Circuit. We're a little bit different. So I've got a case where I'm saying they lied in 2014, and the state is saying it wasn't clearly established until in Sixth Circuit until 2018. So it's kind of complex to give that full argument. We did get a decent case come out in 2018, but also there were prior cases that also said that it was, and we're fussing over that.